Hello, my name is Ashish Joshi. I'm with Joshi Attorneys and Counselors, a law firm in Ann Arbor, Michigan. How do you prove parental alienation in a court of law? It's one thing to make allegations of alienation. It's one thing to allege parental alienation. But when the time comes, how do you prove it in a court of law? The court looks at evidence, not speculation, not allegations, but evidence of parental alienation. Typically, what happens is that a court-ordered evaluation makes a finding of alienation present in the case. It could document the behaviors of an alienating parent. It could also talk about the presence of the signs of alienation in the child. And together, the court-ordered evaluator presents the findings to the court. But when you go through a trial, and if you are representing the targeted parent, how can you, the attorney, prove a case of alienation in a court of law? There are several ways to do it. One of the most common method, and the one that I prefer, is called the 5-factor model. The 5-factor model was designed by Dr. Amy Baker and her colleagues. These are the 5 factors that come together in order to evaluate or to find or to diagnose whether parental alienation exists in a case or not. The factor 1 is that the child is resisting contact with or rejecting a parent. That's the first requirement, that either a child is strongly resisting contact, refusing to see or not having quality time with a parent, and has rejected the parent. Factor 2, there should be presence of a positive, healthy relationship between the child and the now rejected parent. What we look at and what we present evidence of is that before the separation, before the divorce, before things went to hell in the handbasket, there existed a nice, healthy, loving, normal relationship between the child and the now rejected parent. You can show evidence of the rejected parent being present for soccer games, parent-teacher school meetings, nice vacation photographs, regular meetings with the pediatricians, doctors, neighborhood concerts, meetings, everything that a parent normally does to be involved in the child's life. That's factor 2, that before the separation, there was a loving, healthy, normative relationship between the child and the now rejected parent. Factor 3 is absence of abuse or neglect on the part of the rejected parent. We present evidence that the parent who is rejected by the child did not engage in severely abusive or severely neglectful behavior. And this is important. We are not talking about allegations of inappropriate behavior. We are not talking about suboptimal parenting. No one is perfect. A parent who doesn't show up for a few soccer games or who disciplines a child, takes the video games away, or does something that is frowned upon by the other parent or the child does not necessitate and does not result into a rejection. What we are talking about is severely abusive behavior or neglectful behavior that has been found by an independent fact finder, either a Child Protective Services record or a conviction or some objective evidence that the rejected parent has engaged in some behavior which would cause the child to justifiably reject that parent. And we are looking for absence of such evidence. So that's factor 3. Factor 4 is we are looking to present evidence of alienating behaviors on the part of the favored parent. It could be the parent acting alone. It could be the parent acting with allies, other family members, sometimes even court-appointed professionals. But we are looking for specific alienating behaviors that are manifested by the alienating parent. And there are 17 specific behaviors. Not all 17 have to be present. You could have 4 or 5 or 6 behaviors present in a case and still be a case of moderate to severe parental alienation. But we must have evidence of this, not assumptions, not speculations, not conclusions, evidence. And factor 5 is that the child shows signs or manifestations or symptoms of alienation. There are 8 specific symptoms that are consistent with an alienated child, and the child must show 8 or some of those manifestations. Together, this 5-factor model is used in the court to present evidence of alienation. Think of this as a row of 5 empty buckets. As a targeted parent or as an attorney who represents targeted parent, it's your job to fill up each of this bucket with evidence.